Let's talk about how to get the original will if you're going to be in charge of the estate, or getting a copy of the will if you believe you're going to inherit from the estate. In this video, I'll discuss what to do if you're in charge of the probate estate and seeking the original will, what to do if someone won't give you the will, what to do if the will is stashed away somewhere, and what to expect once you get the will. Getting the original will should be pretty straightforward if you're the executor of the estate. California probate has its own vocabulary, so I want you to understand that a person who's nominated to be in charge of estate, nominated in the will to be in charge of the estate, is called the executor. If there is no will, then the person who's in charge is called the administrator. In this video, I'll discuss 3 common situations in which you may either need the original will or a copy of the will. If you're the executor, then you're entitled to take possession of the original will, and either you or your attorney are responsible for depositing it with the clerk of the court for the county in which your deceased loved one resided before they died. If the original will is in the possession of somebody who won't turn it over to you, there's actually a limited form of litigation that can be done in the probate court in order to force them to produce the will. If the will is in a secure area like a safe deposit box or a storage facility, there's also a process that can be used in order to allow you to gain entry either to the safe deposit box or a secured location. In any event, as long as you do this properly, you'll be able to get the original will. If you're a beneficiary or an heir, then almost certainly you want a copy of the will so you'll know what to expect as probate goes forward. Well, for you, this should be simple as well. And that's because when a petition for probate is filed in which somebody is asking for the will to be admitted to probate, a copy of the will has to be attached to the probate petition. And the probate petition, along with some other documents, have to be sent to you at least 15 days before the court hearing on the petition for probate. So what that means is you'll get the petition, you'll also get a copy of the will. Now, do be aware, if you get a copy of the petition and there's no copy of the will attached, then it's important that you go back to the very first page of that petition for probate and see what is actually being requested. If you see on the first page a box checked that says Letters of Administration, that means that the person who's filed probate is saying that there is no will. And of course, if there is no will, then there isn't going to be a will attached to the petition for probate. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.